So you have a lot of experience here, and you wrote the brief for Fire in support of the NRA's position in this case, right?
Along with other members of our team here at Fire, I did file that brief, and we had on that brief with us the National Coalition Against Censorship, the First Amendment Lawyers Association, and the Rutherford Institute.
Okay, right. And so, the Fire's position in this case is one that's in support of the NRA, just so people are understand that. But I do want to have you on to try and give your reaction to what we heard in these oral arguments. But first, let's discuss the basics of this case, right? This is a case that goes back several years to 2018 in the wake of the Parkland shooting. There was a lot of anti-NRA sentiment at the time, and companies were dropping their affiliation with the group. At the same time, the NRA had been selling a concealed carry insurance program that New York officials didn't like and found that parts of it were unlawful under New York law. And so they investigated these insurance programs, and ultimately the insurers were forced to stop providing. The NRA had worked with several large insurers, Chubb and Locked In and others in this program that basically were sort of subcontracting with them to handle the insurance part of the whole arrangement.
Right.
And as part of this investigation and the resulting consent decrees where the insurance companies agreed to stop working with the NRA, the administrator, the financial administrator at the time in New York, her name
Maria Volo.
Maria Volo, right? She's the Volo in NRA v. Volo. She had sent letters to these insurers, and then also is accused of having a private meeting with, I believe it was Chubb, right?
Yeah.
Where she had essentially told the insurers not to work with the NRA anymore because it would create reputational harm because of the NRA being the NRA's mission in gun promotion, as she described it.
Right.
And so the NRA sued over this letter and the meeting and the atmosphere that created, which resulted in the insurers being dropping the NRA and doing no business with them at all, including on any other kind of potential legal insurance policies. And so they argued that this was a violation of their First Amendment rights as an organization. There's viewpoint discrimination going on. And so that's what this case stems from. Am I missing anything in that?
No, that's the gist of it. And it was a series of actions taken in 2018 that were designed expressly to target NRA because of its political viewpoints. And they were undertaken by state officials that have no jurisdiction over the gun rights issue, but instead were simply exerting pressure where the state could to advance the state's political views on guns. And you can agree with them, you can disagree with them, doesn't matter. The question in this case is whether or not it's the legitimate use of state power to leverage regulatory authority over one sector of the economy to put pressure on businesses to have them essentially not do business with the target of your political position.
Right. And so the NRA went through the lower courts. They lost at the appellate court level,
right,
in this case. But then when they appealed to the Supreme Court, the High Court decided to accept it, right?
Yes.
And actually you had the ACLU at that point agreed to represent the NRA
correct,
in the oral arguments. And actually you also had the Solicitor General, the representative of the United States government, the Department of Justice, filing a brief that was not in support of either side, but which, and I think the ACLU lawyer pointed this out during oral arguments, more or less sides with the NRA, agrees that there was at least plausible First Amendment violation here. Now, and actually, I guess this is an important point to get to. Can you explain the state of this case? This is not the merits of this particular case, right?
None of the courts had gotten to the merits. The district court had rejected the state's motion to dismiss the case, saying that there was a plausible First Amendment claim for this sort of indirect pressure to affect someone's First Amendment rights. It went to the Court of Appeals, and the court agreed with the principle that indirect pressure can violate the First Amendment, but that no plausible case had been alleged in the complaint that would violate that standard. And so it then dismissed the case. And that's the basis on which this was taken to the High Court. None of the merits have been decided. This is all based on the allegations of the complaint.
And that matters a lot in this case, right? Because it determines sort of the bar you have to clear in order to win if you're the NRA, right?
Well, the bar you have to clear even to get a day in court, right?
Right.
You still have
to win this like section of the case that we're discussing, that whether or not they're just deciding whether or not there's the motion to dismiss should be upheld, right?
That's right. And so
it's a lower standard, right?
If the NRA wins at the Supreme Court, that gives them a do-over in the lower courts. It doesn't mean that decides the case.
Yeah, they'd have to go back down and hear all this on the merits and prove, like, the meeting that we're discussing. They'd have to present evidence that happened the way that they claim.
That's right.
And so on and so forth, right? And so, that seems like it gives the NRA a pretty good starting place, right? It's a little bit lower. They don't have to win on the merits here. They have to win on this basic concept that this could be a First Amendment violation, right?
Well, that's right. I mean, what this is about is the underlying principles of the case and not about the case itself.
Yes. And so the question here is, if everything the NRA alleges is true, they're assuming that it's true at this point, does that constitute a First Amendment violation?
Correct.